So I hope you all enjoy the conference, and I'm delighted to introduce our next speaker, Laura Dunlop KC, who is President of the Mental Health Tribunal. Laura's been a KC since 2002. She was standing counsel to the Kirk until last year, I think. She was a part-time law commissioner and has been a member of the Mental Health Tribunal since 2016 and president since October of 2019. That's just a very small snapshot of her many achievements. So I would like to ask you to address us now, Laura. Thank you.
Well, good morning, and thank you, Lady Dorian, for the introduction, and thank you to the Council for asking me to speak to you. It's the dreaded PowerPoint, but I think it's a more efficient way to impart information in a short time, although I now realise that because of the Lord President's court commitment, I actually have very slightly more time than I thought I had, which I hope is a good thing, and for you as well, let's hope. So, this is my material. The story of major legislative change in Scotland, the introduction of the tribunal, begins at the bottom with the Millen Report, New Directions, which you can see. Then the bill, which went through the Scottish Parliament early in its new existence in the early 2000s, and you can see the bound parliamentary process there, and then the Act, the Mental Health Care and Treatment Scotland Act 2003, and then on the top the statutory code of practice. So there's quite a lot to it, which I'm hoping to cover in this talk, and I should be able to offer one piece of audience participation. I'm going to talk about the identity of the tribunal as a whole and the identity of members, then the scope of the tribunal's jurisdiction, and then about what decisions may be made. The structure of MHTS remains as it was when the tribunal was established under the 2003 Act. It is a non-departmental public body. It is not part of the first-tier tribunal for Scotland, though it is listed as a tribunal to be transferred into the FTS under the Tribunals Scotland Act 2014. That transfer is currently scheduled to take place before the end of 2026. The administrative structure of the tribunal is that its employees, IT offices and so on are provided by the Scottish Courts and Tribunals Service. So, who are the members? MHTS consists of 3 panels of members appointed by the Scottish Government, with a panel of sheriffs in addition. The main cohort of members subdivide into lawyers, psychiatrists and general members, with around 100 of each. We have far fewer sheriffs. The sheriffs who convene our hearings are largely part-time sheriffs, though we do receive some time from 2 permanent sheriffs. The general members come from 4 specified professions, from social work, nursing, occupational therapy and psychology, or are themselves service users or carers. Around 28% of our general members are service users, and we have service users in both other categories of member as well. With minor exceptions, hearings involving restricted patients require to be convened by a sheriff or by the president of the tribunal rather than by a legal member, and I'll return to the concept of a restricted patient. Who are the patients? First of all, people on a compulsion order alone. A compulsion order will have been imposed by a court under the 1995 Act, following conviction or following acquittal on the basis of mental disorder, or after being found unfit for trial. A restriction order may have been added. That reference to restriction orders takes me to a discrete group of people who, for shorthand, we refer to as restricted patients. Most of them are on a compulsion order plus a restriction order. Additionally, a small group of restricted patients are people subject to a direction, either a hospital direction or a transfer for treatment direction. Those are people who were sentenced to imprisonment, but with a direction that they be sent to hospital, that's a hospital direction, or people who have become unwell while serving a sentence of imprisonment, and that's a transfer for treatment direction. All the direction patients are subject to a regime under the 2003 Act, which is broadly similar to the CORO group, and we do call them all restricted patients. Finally, I should mention, again, this is shorthand, but what we would call the civil patients. Those patients within the tribunal's jurisdiction are people who will be on a compulsory treatment order, so not a CO, but a CTO. Now some statistics. These statistics are for the year to 31st March 2023. That's the last year for which statistics are publicly available, although the statistics to the end of March 2024 should become available in October. You'll see that in that year, 55 people were placed, this is across Scotland, 55 people were placed on a compulsion order. 13 of those people had a restriction order added to the compulsion order. 55 is the lowest number for at least 10 years. The average age of people who were made subject to an order under the 1995 Act was 39. In that year, there were also 22 transfer for treatment directions and, in fact, no hospital directions. I've included the figure for the civil orders as well for comparison's sake, and you can see that in that period, the tribunal made 1,783 compulsory treatment orders. This is the moment for audience participation. There are currently 316 restricted patients in Scotland. This is a multiple choice estimate, so I'm interested to know whether you think that the breakdown of that 316 group of people is A, 300 men and 16 women, B, 268 men and 48 women, or C, 231 men and 85 women. So please just put your hand up. A, who thinks it's A? Right, and B? And a slightly smaller number, and C? A few people. Right, thank you. Well, the correct answer is A. The makeup of the 316 restricted patients in Scotland is 300 men and 16 women, which works out at around 95%. For the disposals I'm speaking about, so disposals on the basis of mental health under the 1995 Act, more widely, so not just the restricted patients, but including the compulsion order on its own patients as well, the breakdown is that 86% of them are men. When does a patient who's on a compulsion order come into the tribunal system? So, if I was allowed Latin, I would say that this is a person on a compulsion order simpliciter, but I think I'm not nowadays. So this is somebody who's on a compulsion order without a restriction order. And what will prompt a hearing for that person? Well, initially, that extension of the order is required. A compulsion order, when first made, lasts for 6 months, unless it's revoked by the responsible medical officer, the RMO. At the 6-month point, only the tribunal can extend the compulsion order. The tribunal should have the information that was before the court, and provision for that to happen is made by regulations. Extension lasts, as it would for a CTO, for a further 6 months. Thereafter, the compulsion order can be extended unaltered by the RMO for 12 months at a time, all of that being subject to the review regime. Variation of the compulsion order, however, with or without extension, is always under the jurisdiction of the tribunal. The review regime follows a 2-year pattern. Every second year, the RMO's extension requires to be reviewed by the tribunal. And patients and others can apply for revocation or variation of the order. The RMO may decide themselves to revoke the compulsion order, and indeed they would have a duty to do so where the statutory criteria for the order are no longer met, and in that instance the tribunal would not be involved. What about the tribunal's jurisdiction for restricted patients? Well, first of all, for restricted patients there is no requirement for extension since there is no provision for the order to lapse, and you'll all be familiar with the expression detained without limit of time. But an application by the patient who is on the Coro combination could bring their situation to the attention of the tribunal. But unless an application is made by a patient or a reference is generated by the RMO, the tribunal will become aware of those patients when a review is required, which is 2 years after the Coro combination was made, and review will be 2 years late thereafter. The regime applicable to people on a direction is broadly similar. What are the possible outcomes of a hearing? For a compulsion order, it would be the same as a CTO, compulsory treatment order, so the tribunal could confirm the extension of the order, it could vary the compulsion order, or it could revoke it. For restricted patients, the decision section in the 2003 Act is a very complex piece of legislative drafting in the 2003 Act, so for anybody who's looked at it, you'll know it's section 193. After some, with a direction equivalent, after some initial turbulence in the Court of Session in the early years of the tribunal, we are now accustomed to the provisions of section 193. What that section does is to compel review of the constituent parts of the regime applying to the patient. So, first of all, the existence of mental disorder, and I should also make the same disclaimer about terminology, that is the terminology which at the moment is in the legislation. That's looked at first, and then there is the serious harm test. Many of you will recall that the introduction of the serious harm test was in fact the first act of the reconvened Scottish Parliament in 1999, following the case of a particular individual. So that is part of section 193. And once the tribunal has looked at the serious harm test, it will move on to look at the remaining criteria for compulsion, which are essentially the availability of treatment and the presence of risk. And then finally, statutory criterion of necessity, which has to be considered in relation to each branch of the package, so both the compulsion order and the restriction order. There is a spectrum of outcomes ranging from revocation of one or both of the CO and RO, or at the other end of the spectrum, a no order decision, which is maintenance of the status quo. Revocation in this context can only take place by the tribunal. If the restriction order alone were to be revoked, the patient would then become subject to the regime which is applicable to people on compulsion orders alone. Now I'm going to speak about conditional discharge. Many patients are hoping for conditional discharge. If a person is conditionally discharged, they will remain subject to the compulsion order and the restriction order. The conditions will be supplied by Scottish ministers, and a breach of those conditions, or indeed following other reasons. The person can be recalled to hospital by warrant. That can operate extremely quickly, and the granting of the warrant by the Scottish ministers is subject to only a criterion of necessity. To a considerable extent, a person recalled from conditional discharge will find themselves back at square one. So, another contents page, some more where, who and what. Where are the patients? Patients on a compulsion order or a choral combination will be in hospital or in the community. People on directions will be in hospital. People who are on the choral combination in hospital will be in the state hospital or in a medium or low secure unit. The 3 medium secure units are listed there: the Orchard in Edinburgh, Roundbank in Glasgow and Rohalion in Perth, or as we always speak of it in the Tribunal, East, West and North. There are 17 low secure units in Scotland. If somebody on the choral combination is in the community, it will be because they are a conditionally discharged person. I should also mention the excessive security jurisdiction. This applies to all patients who are in high security or medium security, and that means it applies to patients on civil orders as well, because there are patients on civil orders in the state hospital and indeed in medium and low secure units. The excessive security jurisdiction has created flow around the hospitals. The person makes an application to the tribunal for a declaratory order that they are being detained in conditions of excessive security, and if they are successful, an order is made to try to bring about their move. Where do we hold our hearings? In essence, where the patient is. How do we hold our hearings? We hold them in person, we hold them over WebEx, and post-COVID we are still holding a proportion of our hearings on the phone. Who else might be at a hearing? Well, obviously, civil patients are at most of our hearings. That's the majority of our hearings. And as I've already said, some patients on civil orders are in the secure units. I'm also going to mention Schedule 3 to the Act, which empowers the Tribunal to make a compulsory treatment order to follow continuously for someone on a direction who would otherwise have to be released from hospital at the end of their sentence. At a hearing, there might be a named person. Under the legislation, this is a trusted other person appointed by the patient, really to be alongside them. And also our victim jurisdiction, we currently have 61 people who wish to and do receive notice of specific restricted patient hearings, and they are offered the chance to make representations to the tribunal. Finally, some short comments. What lies ahead? Well, there will be the introduction of recorded matters for patients on compulsion orders. A recorded matter under the legislation is care, treatment or a service which the tribunal thinks a patient should be receiving. That's always been an option for somebody on a compulsory treatment order, but it will become available to someone on a compulsion order as well, and that's the consequence of a judicial review. My second comment about no conviction is that in practice, sitting on a tribunal for somebody who was not convicted, so for whom there is no extract conviction, can be difficult because there may be less clarity about what it was the person did. I've also mentioned the therapeutic majority. This is not often commented on in my experience, but sitting as a lawyer with a doctor and a mental health nurse, for example, can produce a different dynamic in decision making. And then finally, I've made a point about the rhythm. I think that the periodicity of what we do in the tribunal means that we are part of the patient's therapeutic journey, not a big part, but it will be part of their experience. And this is where I got the title, obviously, that they will appear before 3 people at a tribunal at specific times. And a couple of final comments. I'm just going to look at the time. Yes, I know I have slightly overrun, but actually it's all right for the coffee break. So I'm just going to say a couple of final things which are not up there at all. The first is that there is a bit of a Goldilocks issue. And by that, I mean, how can the length of someone's stay in the mental health system be just right? And Lord Carloway referred to this in his opening remarks, and it's also in the paper which is in your pack, that there is a sense of, well, might this be too lenient? And, you know, that word has been used. So I thought I would just, if only as an example from the other side of that particular coin, include this, that in one of the early cases in the Court of Session in the mid-noughties, one patient, whose case has become quite a seminal one, was somebody who was admitted to the state hospital in 1970 following a conviction for a breach of the peace. After that, he remained in the state hospital for almost all of the intervening period until he was transferred to medium security in 2014. So I appreciate that's only one example, but I think it does make the point that Lord Carloway made about the difficult decision for advisors that something could lead, or advice to seek a mental health disposal could lead to a very long period of detention versus perhaps a short sentence. And absolutely finally, I want to pay tribute to all who are engaged in working with this group of patients because it is painstaking work. So thank you.